The Supreme Court chamber fell silent as Justice Amy Coney Barrett leaned forward, a dismissive smile playing across her lips. The newest member of the nation's highest court adjusted her black robe and looked down at former Florida Attorney General Pam Bondi, who stood confidently at the podium. Just moments earlier, Barrett had interrupted Bondi's argument with a question that carried a distinct tone of derision. "Ms. Bondi," Barrett said, her voice carrying through the marble chamber, "you're arguing that the constitutional framework supports your position, but I'm struggling to find any precedent that backs your interpretation. Perhaps I've missed something in my years on the bench." Several justices exchanged glances as soft laughter rippled through the gallery. The mockery was subtle but unmistakable, a Supreme Court justice appearing to belittle a seasoned attorney before the highest court in the land. Barrett's slight smile suggested she believed she had exposed a fundamental weakness in Bondi's case. Bondi gripped the edges of the podium, her knuckles whitening slightly. She had 30 seconds remaining in her argument. 30 seconds to respond to this dismissal from the bench. What happened next would not only shock the Supreme Court, but would lead to one of the most remarkable moments in recent legal history, leaving Barrett visibly shaken and the legal community in an uproar. Before we reveal what Bondi said that silenced the courtroom and turned the tables so dramatically on Justice Barrett, comment where you're watching from, and don't forget to subscribe for more political truth bombs that the mainstream media won't show you. Justice Amy Coney Barrett's meteoric rise to the Supreme Court had made her a powerful figure in American jurisprudence. Appointed in 2020 following a contentious confirmation process, Barrett had quickly established herself as an intellectual force on the bench. With her sharp questioning and originalist approach to constitutional interpretation, she had earned respect even from those who disagreed with her judicial philosophy. At 51, Barrett represented a younger generation of conservative legal thinking, a former Notre Dame law professor whose academic credentials were impeccable. Her 7 children and devout Catholic faith had made her a cultural icon to conservatives, while progressives viewed her with deep suspicion, particularly regarding cases touching on religious liberty and executive power. In the courtroom, Barrett had developed a reputation for occasionally employing a gentle but pointed mockery toward arguments she found lacking in constitutional foundation. As the junior justice, she often waited until later in oral arguments to speak, making her interventions all the more noticeable. Pam Bondi, standing before the court that morning, brought her own formidable background. As Florida's first female attorney general, Bondi had prosecuted high-profile cases and defended state laws before appellate courts. After leaving office, she had built a successful private practice focusing on constitutional challenges and had argued 3 previous cases before the Supreme Court, winning 2 of them. At 58, Bondi's blonde hair and polished appearance belied a razor-sharp legal mind and a prosecutor's instinct for the jugular. Those who had faced her in court knew she was most dangerous when underestimated, something Justice Barrett was about to learn firsthand. The case before the court that day, Meridian Industries versus Department of Labor, presented complex questions about federal agency power. Bondi represented Meridian, challenging what they viewed as regulatory overreach. The implications extended far beyond this single corporation. The court's ruling would potentially reshape the relationship between federal agencies and private businesses nationwide. All 9 justices recognized the stakes. A ruling for Bondi's client would curtail agency authority that had gone largely unchallenged for decades. A ruling against would cement administrative power in ways that worried conservatives fearful of an expanding regulatory state. The courtroom was packed with journalists, law students, and representatives from regulatory agencies across Washington. SCOTUS blog had labeled it the most significant administrative law case in a generation, and constitutional scholars had been debating the potential outcomes for months. As Bondi had begun her oral argument, the justices had engaged in typical questioning. Justice Sotomayor had pressed her on worker protections, while Justice Alito had seemed sympathetic to her position on agency overreach. When Chief Justice Roberts asked about remedies, Bondi had provided a detailed, nuanced response that appeared to satisfy him. Then came Barrett's intervention, not a substantive question about legal principles, but the seemingly dismissive challenge about precedent, delivered with that slight, knowing smile. The subtext was clear to everyone in the courtroom. Barrett believed she had identified a fatal weakness in Bondi's position and was almost toying with her. What Barrett didn't know was that Bondi had spent 3 months preparing for this exact moment, anticipating this specific line of attack. As Bondi took a deep breath and prepared to respond, the dynamics of power in the courtroom were about to shift dramatically. "Justice Barrett," Bondi began, her voice steady and respectful despite the provocation, "I appreciate your question about precedent." She paused momentarily, making eye contact with Barrett. "In fact, I'd like to direct the court's attention to 3 cases that provide the foundation for our argument today." Without consulting notes, Bondi launched into a precise citation of Whitman v. American Trucking Associations, 2001, followed by the exact language from Justice Scalia's majority opinion limiting agency discretion. She then seamlessly transitioned to FDA v. Brown and Williamson Tobacco, 2000, quoting specific passages about administrative authority requiring clear congressional authorization. The justices began paying closer attention, with several straightening in their seats. Barrett's smile faded slightly as Bondi continued without hesitation. "But perhaps most relevant to Justice Barrett's question," Bondi continued, her voice gaining strength, "is your own opinion in Collins v. Yellen from 2021, where you wrote, and I quote directly, 'When interpreting a statute, courts must be careful not to extend federal agency power beyond the boundaries clearly set by Congress.'" A subtle murmur ran through the courtroom. Bondi had just quoted Barrett's own words back to her, words that directly supported Bondi's position in the current case. Several journalists scribbled notes furiously, while law clerks exchanged glances. Barrett's expression tightened, almost imperceptibly. "Ms. Bondi, Collins addressed a different regulatory framework entirely. The context was, with respect." "Justice Barrett," Bondi interjected with practiced deference, "the principle you articulated in Collins applies with equal force here. If I may elaborate." This was unusual. Attorneys rarely interrupted Supreme Court justices. The tension in the courtroom ratcheted higher as Barrett, clearly surprised by the pushback, nodded slightly. Bondi didn't waste the opening. She turned to a detailed analysis of 5 more cases, drawing a clear line from established precedent to her client's position. As she spoke, she maintained eye contact with Barrett, whose initial dismissive demeanor had vanished, replaced by a focused intensity. "Furthermore," Bondi continued, "this court's decision last term in West Virginia v. EPA, which Justice Barrett joined, reinforced the major questions doctrine. That doctrine is precisely what we're invoking today." Justice Elena Kagan leaned forward. "Ms. Bondi, West Virginia addressed environmental regulations specifically. Are you suggesting its scope extends to labor regulations as well?" This intervention gave Bondi the perfect opportunity to expand her argument. For the next 3 minutes, she navigated a complex interchange with Kagan and Gorsuch about administrative law principles, demonstrating mastery of the subject while continually returning to the precedents Barrett had suggested didn't exist. The trial dynamic in the courtroom had shifted. What began as a seemingly dismissive moment from Barrett had evolved into a showcase for Bondi's exceptional command of constitutional law. Barrett's initial laughter now seemed misplaced, even inappropriate, given Bondi's thorough response. Then came the moment that elevated the tension even further. Justice Barrett, perhaps attempting to reassert control of the exchange, returned to her original challenge. "Ms. Bondi, while these cases are certainly relevant, none directly addresses the specific agency action at issue today." The Department of Labor's authority under this particular statute has different contours than the examples you've cited. Barrett's tone remained professional, but carried a defensive edge not present before. The justice who had laughed minutes earlier now appeared to be searching for ways to distinguish the precedents Bondi had so effectively marshaled. Bondi nodded respectfully, but those who knew her recognized the look in her eyes. The same look she had when delivering closing arguments in high-stakes prosecutions. She was about to deliver her most powerful point, the one she had prepared knowing that Barrett's judicial philosophy had a potential vulnerability on this very issue. Justice Barrett, you raised an excellent point about specific statutory context, Bondi acknowledged. With the court's permission, I'd like to address that directly with reference to the textualist principles that you yourself have championed throughout your judicial career. The trap was set. Barrett had built her reputation on strict textualism, the idea that the exact wording of statutes should govern rather than legislative intent or broad policy goals. Now Bondi was about to use Barrett's own judicial philosophy against her, setting up the decisive moment that would stun the courtroom. Justice Barrett, Bondi said, her voice clear and confident. In your 2018 article in the Columbia Law Review entitled Statutory Interpretation and the Primacy of Text, you wrote that, when a statute's text is clear, agencies may not reinterpret that language to expand their authority, regardless of policy objectives. Bondi paused, allowing the quote to resonate through the chamber. Barrett's own words hung in the air between them. The statute at issue today contains nearly identical language to the one you analyzed in that article, Bondi continued. Specifically, on page 147 of your article, you critiqued the D.C. Circuit for allowing an agency to expand a similarly worded provision. A hush fell over the courtroom. Bondi wasn't just citing cases now, she was using Barrett's own academic writing to dismantle the justice's dismissive question. Several of the other justices shifted uncomfortably in their seats, recognizing the rhetorical checkmate taking shape. In fact, Bondi continued, removing a document from her folder, I have here the text of the statute you analyzed compared with the Department of Labor provision at issue today. The structural and linguistic parallels are striking. She handed copies to the clerk for distribution to the justices. As Barrett received hers, the cameras caught a momentary widening of her eyes, recognition that her own scholarly work contradicted the position she had just taken from the bench. Furthermore, Bondi pressed her advantage. Just last year in your Madison lecture at NYU Law School, you emphasized that consistency in judicial philosophy is the bedrock of legitimate constitutional interpretation. That consistency principle is exactly what we're asking the court to apply today. The reference to Barrett's lecture, delivered to great acclaim just months earlier, landed with precision. Barrett had publicly committed herself to consistent application of interpretive principles, regardless of the political implications of cases. Now Bondi had expertly backed her into a corner, either maintain consistency with her own stated principles and rule in Bondi's favor, or contradict her own judicial philosophy. Justice Sotomayor, perhaps sensing Barrett's discomfort, attempted to redirect the discussion. Ms. Bondi, returning to the statutory question, one final point, if I may, Justice Sotomayor, Bondi said respectfully but firmly. The textualist approach that Justice Barrett has so eloquently championed throughout her career, in her scholarship, in her opinions on the Seventh Circuit, and in her decisions on this court, leads to only one conclusion in this case, that the Department of Labor exceeded its statutory authority. Bondi turned back to Barrett, whose expression had transformed completely from the dismissive smile of earlier. The precedents exist, Justice Barrett. They exist in this court's decisions, in your own written opinions, and in the constitutional principles you have consistently defended. When applied to the clear statutory text in this case, they compel a ruling for my client. The courtroom remained silent for a long moment. Barrett's initial laughter seemed a distant memory, replaced by the reality that her own judicial record had been used to systematically dismantle her position. What had begun as a seemingly routine oral argument had transformed into an extraordinary moment of intellectual confrontation at the highest level of the American legal system. "Thank you, Ms. Bondi," Chief Justice Roberts said finally, breaking the tension. "Your time has expired." As Bondi gathered her notes and stepped away from the podium, Barrett was seen writing rapidly on her notepad, her earlier confidence replaced by intense concentration. The justice who had laughed now appeared deeply troubled, perhaps even emotionally affected by the comprehensive way her own words and principles had been turned against her. The government's attorney approached the podium for his rebuttal, but the energy in the room had fundamentally changed. Everyone present, justices, attorneys, journalists, and observers, had just witnessed a remarkable reversal. A Supreme Court justice had laughed dismissively at an advocate, only to have her own judicial philosophy and writings used to deliver one of the most effective oral arguments in recent Supreme Court history. The impact of the Bondi-Barrett exchange reverberated far beyond the marble walls of the Supreme Court. As participants filed out of the courtroom, journalists rushed to file their stories, many leading with variations of "Barrett challenged by her own words" and "Bondi turns tables on justice using Barrett's writings." Within hours, legal blogs were dissecting the confrontation. Above the Law posted a detailed analysis titled, "When Laughing Backfires, Barrett's Dismissive Moment Becomes Bondi's Triumph." SCOTUS blog's evening recap called it a rare moment of a justice being directly confronted with her own inconsistency and visibly affected by the realization. Video clips of the exchange, particularly the moment when Barrett's expression changed upon receiving the document comparing the statutes, spread rapidly across social media. The hashtag the Bondivs Barrett began trending nationally, with legal commentators from across the political spectrum weighing in. Conservative legal scholar Jonathan Adler tweeted, "Whatever your views on the case, Bondi's preparation was masterful. Using Barrett's own textualism to make her case shows exceptional strategic thinking." Liberal professor Lawrence Tribe added, "Today, we witness something remarkable, a justice's own judicial philosophy being used to reveal potential inconsistency. This is how oral argument should work." For Barrett personally, the fallout was immediate and multifaceted. Court sources reported that she canceled her afternoon meetings and remained in her chambers long after the other justices had departed. The following day's arguments found her notably more reserved in her questioning, with none of the dismissive tone that had characterized her exchange with Bondi. Media coverage extended beyond legal circles to mainstream news. The Washington Post ran a front-page story analyzing Barrett's judicial record for similar inconsistencies, while the New York Times published an op-ed titled, "When Judicial Philosophy Meets Real-World Application, Lessons from the Barrett-Bondi Moment." Conservative media initially attempted to downplay the exchange, but as video continued to circulate, even friendly outlets acknowledged Barrett's difficult position. Fox News legal analyst Andrew McCarthy noted, "Justice Barrett is one of our brightest legal minds, but today Pam Bondi exposed a potential inconsistency that will be difficult to reconcile in the court's opinion." For Pam Bondi, the aftermath brought professional acclaim across the legal community. Law schools requested the notes from her argument to use in appellate advocacy classes. 3 major law firms reportedly approached her with partnership offers. Within days of the argument, when interviewed leaving a subsequent court appearance, Bondi downplayed the personal aspect of the exchange. "This wasn't about Justice Barrett or me," she told reporters. "It was about the consistent application of constitutional principles. The court deserves enormous respect, but advocates have an obligation to point out when judicial application of principles appears inconsistent." The measured response only enhanced Bondi's standing as a serious constitutional lawyer rather than someone seeking personal publicity from the confrontation. Behind the scenes, the exchange affected the court's deliberations significantly. Sources close to the court reported that at the justices' private conference, where they tentatively voted on cases following oral arguments, Barrett spoke at length about reconsidering her initial position. The advocate made points that require serious engagement, Barrett reportedly told her colleagues, in a rare acknowledgement that an oral argument had substantially influenced her thinking. 3 justices who had initially leaned toward the government's position indicated they were now reconsidering in light of the textualist arguments Bondi had presented. When the court's opinion was finally issued 3 months later, the impact of the exchange became official. In a 6-3 decision, the court ruled in favor of Bondi's client, with Barrett writing a concurring opinion that directly addressed the textualist principles raised during oral argument. Consistency in applying interpretive methodologies is essential to the rule of law, Barrett wrote. Where a statute's text is clear, as it is here, agencies may not expand their authority beyond Congress's explicit grant, regardless of policy objectives. The language echoed almost exactly what Bondi had quoted from Barrett's own academic article. Legal scholars noted that Barrett's concurrence appeared to be both a judicial opinion and a personal statement, an acknowledgement that her initial dismissive approach to Bondi's argument had been misplaced. Without directly referencing the oral argument exchange, Barrett had essentially validated Bondi's position through her written opinion. The long-term implications extended beyond this single case. Law professors began using the exchange in classes on appellate advocacy as a perfect example of how to respectfully but firmly challenge a hostile judge. Constitutional law courses incorporated the case as a study in textualist methodology and its practical application. For the regulatory state, the decision represented a significant constraint on agency power, with federal departments now required to obtain clearer congressional authorization before implementing major policy changes. Business groups celebrated the decision as a check on administrative overreach, while progressive organizations worried about the implications for environmental and worker protections. 6 months after the decision, when Bondi argued another case before the Supreme Court, observers noted a marked difference in Barrett's approach. Gone was any hint of dismissiveness. Instead, Barrett engaged with Bondi's arguments thoughtfully and respectfully, asking substantive questions without the edge that had characterized their previous encounter. A junior clerk was reported to have overheard Barrett telling a colleague, before the second argument, "I learned an important lesson about assumptions last time Ms. Bondi appeared before us." It was perhaps the most telling acknowledgement of how thoroughly Bondi had transformed what began as a moment of judicial mockery into a triumph of constitutional advocacy. The Bondi-Barrett confrontation ultimately became more than a momentary courtroom drama. It evolved into a case study of how preparation, knowledge, and strategic thinking can overcome even the most daunting power dynamics. When a Supreme Court justice laughed dismissively at an advocate, few would have predicted it would end with that same justice essentially validating the advocate's position in a written opinion that would shape constitutional law for decades to come. What this remarkable legal confrontation teaches us is that in America's system of justice, even those in the highest positions of authority can be held accountable through the power of well-reasoned argument and meticulous preparation. When Pam Bondi walked into the Supreme Court that day, she carried not just her client's case, but a profound understanding of Justice Barrett's own legal philosophy, knowledge that proved more powerful than the momentary advantage of a justice's laughter. If you found this analysis revealing, please like and subscribe to our channel for more deep dives into the confrontations shaping America's legal and political landscape. Comment below with your thoughts. Was Barrett right to reconsider her position, or should justices hold firm regardless of oral arguments? And which Supreme Court case would you like us to analyze next? Until our next report, remember that in America's courtrooms, as in life, preparation and principle still matter more than position and power.